Well, a very warm welcome to you all to our workshop today on evidence and European Court of Human Rights. It sounds quite broad, but I think the focus is going to be very much on criminal evidence. Right, Dimitrios?
Yes.
Criminal. I think everyone's going to talk about criminal evidence and the Court of Human Rights. And just a few things to start with. The idea is to try and keep the presentations quite short, about 20 minutes. That we've got 20 minutes for discussion. It's great if everyone thinks about questions and is ready to get involved in the discussion. Give Federico a drilling then, and then at the end, after the coffee break, hopefully we'll have a chance to discuss maybe some of the broader issues. So that's kind of like the plan: 20-minute presentations, 20 minutes discussion, and then at the end of the workshop, maybe an opportunity to discuss some of the broader themes. Great. Well, that was my introduction. We're running absolutely according to schedule now, 9:05. It's a great pleasure to introduce Federico Picinali from the LSE. He's an expert, obviously, on evidence law and criminal procedure law, and he's going to talk today about relevance, epistemic injustice, and fair trials. Federico.
Thanks so much. So I'd like to thank the organizers of the conference and Sarah as coordinator of this workshop for inviting me here. The argument that I want to defend can be presented in a nutshell as follows. I claim that the European Court of Human Rights should concern itself more frequently than it currently does with assessments of relevance and of probative value by the national institutions. And this is because these assessments might instantiate so-called epistemic injustice and therefore might render the trial unfair. Okay, so this is my argument. I could end the talk here, but I'm actually going to use the rest of the talk to try and unpack the argument, okay? So the European Court of Human Rights does not normally concern itself with assessments of relevance and probative value by national courts. And in fact, there's a long line of cases in which the court says that the all assessment of admissibility, which contains the assessment of relevance and to an extent the assessment of probative value, lies outside the province of the court. Takes the case of Camido versus Russia or the later case of Berani versus Albania. And in fact, I think it's worth quoting from this latter case just to understand what is the position of the court on the matter. So the court says, the court reiterates at the outset that the admissibility of the evidence is primarily governed by the rules of domestic law, and that, as a rule, it is for the national courts to assess the evidence before them, establish facts and interpret domestic law. The court will not in principle intervene unless the decisions reached by the domestic courts appear arbitrary or manifestly unreasonable. In fact, it's important to point out that both Kamidov and Berani represent an exception to the general rule of non-interference that I've just rehearsed. So in both cases, the court argued that the national courts reached some factual conclusion that were so arbitrary that the trial, as a result, was unfair. But the general rule of non-interference stands. So what are the reasons for this rule? What are the reasons as to why the European Court of Human Rights exercises self-restraint with respect to assessments of relevance and probative value? There may be a few reasons. One of them is the fact that national institutions are closer to the facts. And with this metaphor of closeness, the attempt is that of conveying that national institutions hear the evidence firsthand, and therefore they are in a better epistemic position than a court that would otherwise have to decide on factual matters on the basis of transcripts or documents. There's also another reason, which is the cost of reopening issues that have already been dealt with at the national level. Now, I don't think that either of these reasons is particularly strong, but there's a third one that I want to focus my attention on. And this is that assessments of relevance and probative value are part of the quaestio facti, and therefore they're seemingly irrelevant to the project of normative harmonization that the European Court of Human Rights is pursuing. So let me expand on this last reason. As far as assessments of relevance and probative value are concerned, one might argue that a reason for the self-restraint of the court is that because these assessments are part of the quaestio facti, they may well be inaccurate, but they may not also be unjust. In other words, whilst they might flout epistemic values, they might not also flout moral values, such as the moral rights that the court is enforcing, including the right to a fair trial. And in fact, there seems to be a widespread understanding that these assessments are pretty much irrelevant from the point of view of moral values, including fairness. To be more precise, the understanding seems to be that insofar as these assessments undermine fairness, this is exclusively because of the inaccuracy of the assessment. And it is only on very rare occasions that these assessments are so inaccurate that they render the trial unfair. Take the cases of Kamidov and Berani that I mentioned earlier. In these cases, the court censures some factual conclusions reached by national courts and argues that they render the trial unfair. But the focus of the court there is precisely on the inaccuracy or lack of epistemic justification of these assessments. In other words, the apparent position of the courts, and I contend that this is also a widespread position in the legal community, is that the unfairness that is generated by assessments of relevance and probative value is always mediated by their inaccuracy. So it cannot depend on properties of the assessment other than their inaccuracy. Okay? So then we can outline an argument for self-restraint based on the third reason that I mentioned earlier. So the argument goes like this. The unfairness of assessments of relevance and probative value always depends on their inaccuracy. It is only on very rare occasions that these assessments are so inaccurate as to render a trial unfair. Therefore, the European Court of Human Rights, which acts as protector of moral rights, including fairness, should not concern itself with this assessment as a general matter. It is only on very rare occasions that it should concern itself with these assessments. Okay. Now, what I want to do here is to take issue with this received understanding of assessments of relevance and probative value. I want to argue that these assessments are far from irrelevant from a moral point of view. Okay? More specifically, I want to argue that the moral significance of this assessment does not depend exclusively on their inaccuracy, but might depend on other properties of the assessment. I argue that these assessments might undermine the fairness of a trial quite irrespective of whether they are accurate or inaccurate. They might undermine the fairness of the trial when they instantiate so-called epistemic injustice, a concept that I'm going to clarify in a moment. So the bottom line of my argument is that the European Court of Human Rights, which sees itself as the protector of fairness, should be much readier than it currently is to interfere with assessments of relevance and probative value, and it should be willing to declare a trial unfair on the basis of an assessment that instantiates epistemic injustice, and not exclusively on the basis of an assessment that is so inaccurate as to render the trial unfair. Okay? So, unfairness is not exclusively mediated by inaccuracy. The starting point of my analysis is a critique of what William Twining calls the rationalist tradition of evidence, legal epistemology, sorry. Now, this is a phrase that is probably very familiar to all of you, but roughly what rationalist tradition of legal epistemology means, it's a way of thinking about evidence and legal fact-finding that has its roots in the empirical philosophy of people like Bacon and Mill, and that has informed the common law model of adjudication, as well as modern and contemporary evidence law scholarship. When we assess the relevance or the probative value of the evidence, we tend to rely on generalizations. And here I'm making, I think, both a descriptive and a normative claim. What is a generalization? To keep things as simple as possible, a generalization can be described as a statement to the effect that evidence of a certain kind is or is not indicative of a certain fact that we intend to prove. Now, this raises immediately a question. Where do these generalizations come from? And there is a quote from Analysis of Evidence by Anderson, Schumann, Twining, which gives us the answer that the rationalist tradition gives to this question. So I'm going to read the quote. Judgments about probabilities, including, therefore, assessments of relevance and probative value, have, generally speaking, to be based on the available stock of knowledge about the common course of events. This is largely a matter of common sense. This answer seems to assume that there is a single stock of knowledge to draw generalizations from, such that there is indeed a sense that is common within a certain epistemic community. But this answer is obviously imprecise, at best. And in fact, the very philosophy that allegedly the rationalist tradition derives from, so empirical philosophy, is teaching us that knowledge comes from experience rather than exclusively from theoretical musings. And obviously experience is not constant across society, okay? So my experience is different from yours, such that we probably have a different stock of knowledge, even though I do admit that our stock of knowledge will have a common denominator. And in fact, I want to stress that this is a point that Michele Tarufo himself made in his work on common sense. Common sense is not constant across a society. So the hasty assumption of the rationalist tradition that there is a single stock of knowledge begs a series of questions. And one of them, possibly the most prominent, is what is a stock of knowledge that has traditionally been relied upon when making assessments of relevance and probative value? And that plausible, albeit partial answer to this question is that this is a stock of knowledge that is dominant in a society that is characterized by phenomena such as sexism, racism, ableism, classism. In other words, it's a stock of knowledge of white, middle, or upper class, able-bodied men. Notice that this answer has been at the center of feminist and criminal race theory critiques of the law of evidence for the last 30 years. So I'm not making a new claim at all. And I do accept that the answer would have to be contextualized. So someone would have to assess to what extent this answer is accurate with respect to specific jurisdictions. But this is not what interests me here. Instead, what I want to argue for is the claim that depending on which stock of knowledge is relied upon in making assessments of relevance and probative value, a part in the proceedings might suffer epistemic injustice, therefore unfairness. And in particular, I have in mind two possible scenarios. The first scenario is the one in which the stock of knowledge of a party in the proceedings is ignored or dismissed due to a bias against the party, qua member of a particular social group. Whereas the second case is that in which, whilst the stock of knowledge of a party is not necessarily dismissed, a stock of knowledge alternative to that is ultimately preferred, which contains generalizations of a biased kind that attack the credibility of that party, qua member of a particular social group. In other words, generalizations that unjustifiably suggest that the testimony of that party has little or no probative value. I'm going to give you an example of these scenarios in a moment, but I want to continue with the theory for a little longer. So I claim that in these cases, the party suffers epistemic injustice, more specifically, testimonial injustice. So these concepts, as some of you probably know, have been introduced by philosopher Miranda Fricker in her book, Epistemic Injustice in 2006. What does this injustice consist of? If we refer this injustice to the context of the criminal process, it consists in being denied a role that is owed to the party. More specifically, the role is that of a giver of knowledge in the proceeding, is that of participant in the epistemic enterprise of criminal fact-finding. And why do I say that this role is owed to the party? It is owed to the party because of the right that the party has to a fair trial. I'm going to elaborate a bit more later on the connection between epistemic injustice and unfairness. But the point here is that epistemic injustice, therefore this sort of hindrance that is put to the participation of the party in the proceeding, generates unfairness. Okay? And to restate a point that I made earlier, this unfairness is not mediated by the inaccuracy of the assessment of relevance and probative value. It follows directly from the epistemic injustice. Okay? Now, more often than not, it will be the case that an assessment that is epistemically unjust is also inaccurate. But this is irrelevant to my argument here. So I want to give a couple of examples now of the two scenarios that I've mentioned a moment ago. In fact, I don't know how widely the abstract circulated, but in that abstract, I've already given an example of the first scenario. So the first scenario is the one where the stock of knowledge of a party is dismissed or ignored in the assessments of relevance and probative value. The example that I've given in the abstract is that of the assessment of the probative value of a black person's flight from the scene of the crime. I'm not going to talk about that example again, but I'm happy to come back to it in the Q&A. So now I'm going to read you a vignette which contains another example. A black individual is tried for a crime of street violence, and the court and fact finder consider it relevant and incriminating that this individual penned rap lyrics with a violent content. It will seem exoteric to you, but there's plenty of these cases going on in England and Wales and in the US. In drawing this conclusion, the court and fact finder ignore or dismiss information about the stylistic rules and the topoi of the genre of rap, according to which verbal violence, exaggeration, and bragging about committing or planning to commit violent acts are widespread, and far from being evidence of a propensity towards physical violence, they are an outlet for frustration that may well serve as a substitute for or a curb on physical violence. Of course, there may be cases in which the correspondence between the words of a lyrics and the crime charge is so striking that denying the relevance of the former would be unreasonable. In other words, the generalization linking violent lyrics to physical violence may well have a range of sound application. But in order to apply it soundly, one would need to consider the perspective, the stock of knowledge of the defendant, that is, the rules and topoi of the genre of rap, and to exclude that they provide an innocent explanation for the violent lyrics. The fact that these rules or topoi are not normally considered in court, and here I can restrict my statement to England and Wales, if you want, is a symptom of the pervasive racist stereotype that associates black individuals and black youth in particular with street violence. Okay? So, with reference to cases of this kind, what I advocate for can be called epistemic inclusivity. So my point is not that the innocent explanation of flight from the scene of the crime or violent lyrics should prevail. Rather, the point is that if it does not prevail, this should be notwithstanding the fact that the stock of knowledge of the defendant is being considered. In other words, no conclusion about the relevance or probative value of this evidence can be reached without considering the stock of knowledge of the defendant, lest epistemic injustice occurs. I now come to the second example. So the second scenario is that of cases in which the stock of knowledge of a party is not necessarily ignored, but a stock of knowledge is preferred to it, which contains generalization that effectively silence the party. Now, cases of this kind, I think, are much more familiar to evidence law scholars, and in fact, they've been discussed for many years now, and I'm particularly referring to the vast literature on the so-called rape myths. I don't know if you're familiar with the term, but rape myths can be described as biased generalization to the effect that a female complainant in a trial for a sexual offense is not credible due to facts about the complainant that are by and large irrelevant to credibility. So I could discuss more than one example, but I'm limiting myself to reading a vignette that is based on this scenario. So in a trial for a sexual offense, the court allows defense counsel to argue that the testimony of the complainant about her lack of consent has no probative value because of the clothes she was wearing at the time in which the alleged crime took place, because of the fact that she had an active sexual life, and because of a delay on her part in reporting the alleged crime to the police. This reasoning relies on biased, read sexist, generalizations about the relationship between, on the one hand, attire, sexual history, delay in reporting, and, on the other hand, consent. Allowing for these generalizations to be aired in court may result in an unwarranted dismissal of the complainant's testimony by the fact finder. So the point here again is not that the testimony should be believed. Rather, the point is that if it is not believed, this should not be because of the biased generalizations. Otherwise, epistemic injustice occurs. Now, I'm moving towards the conclusion, in which I try to elucidate the link between epistemic injustice and unfairness. What does unfairness mean? Obviously, this is $1 million question, but I will limit my assessment to what is likely to be the interpretation of unfairness on the part of the European Court of Human Rights. And here I allow myself to rely on the work of John Jackson and Sarah Summers that attempt to give an interpretation of what is the court's view on this right. And the interpretation is one according to which fairness revolves around the concept of participation in the proceeding. So I'm going to quote from John Jackson and Sarah Summers. Fairness demands that those accused of criminal offenses have the opportunity to challenge the evidence leveled against them and to present their own evidence in adversarial proceedings. End of the quote. And in fact, if someone studies, and I'm conscious of the fact that I have at my left an expert on this topic, the issue of improperly obtained evidence, and the European Court of Human Rights jurisprudence on this issue, they will see that very often in the balancing exercise that the court engages in, one of the factors that has most importance is whether the defendant was given an opportunity to challenge the admissibility of the evidence. Take the cases of Giallo and Alec for an example. Stefan Trexel as well gives an interpretation of fairness that revolves around the concept of participation. He says that fair proceedings are equitable, balanced, giving each side an equal chance to present its point of view. And he adds to this, I think, a very interesting conceptual point on fairness, which is that fairness is not an individual right. Okay? What he says is, and I'm quoting, "In my understanding, it would be grotesque, absurd, completely illogical to claim fairness for one participant alone." The insight here is that a trial cannot be fair unless it is fair for everyone involved. Okay? In other words, if fairness is about equitable and equal and balanced treatment, then it has to be there has to be an equitable and balanced treatment for everyone involved. Or to put it yet in another way, fairness seems to presuppose the existence of at least two terms or two parties that are to be treated fairly. Okay, so the bottom line is not only the defendant but also the complainant has a right, or at least a protected interest to a fair trial. Now, I'm fully aware of the fact that the European Court of Human Rights has not really reached this conclusion. The European Court of Human Rights tends to recognize a right to a fair trial for the complainant only when the complainant has brought a civil action in the criminal proceedings. But I'm going to leave this issue aside for the moment. Let's assume that both complainant and defendant have a right to a fair trial, therefore they have a right to participate in the proceedings. Okay? So then what happens when epistemic injustice in the assessment of relevance and probative value occurs? Fairness is denied. And why is it denied? Because the parties are hampered in their ability to participate in the proceeding, more specifically to the participate in the epistemic enterprise of criminal fact-finding, and they are hampered through having their voice, their word, their experience dismissed as unworthy of consideration or credit. And I should add, unjustifiably dismissed, where the element of injustice resides in the prejudice or the bias that prompted the dismissal. Okay? So, epistemic injustice generates unfairness. Therefore, if the European Court of Human Rights concerns itself with unfairness, it should concern itself with assessment within which epistemic injustice might occur, i.e. assessments of relevance and probative value. Now, of course, I started off by mentioning some reasons for the self-restraint of the court. The argument from closeness, the argument from costs. I said already that I don't think either of these arguments is strong enough. But in any case, my main point here is that if the court sees itself and prides itself as being the protector of fairness, then it should be much readier than it currently is to interfere with assessments of relevance and probative value. And it should be willing to arrive at the conclusion that a trial was unfair because of the epistemic injustice that was instantiated by this assessment. Not exclusively because of the fact that these assessments are so inaccurate as to render the trial unfair. Okay, again, the point is fairness is not exclusively mediated by inaccuracy. I want to conclude by mentioning a recent case that some of you may be familiar with. That sees my home country, Italy, chastised by the European Court of Human Rights, which is certainly not a rare event, is the case of JL versus Italy. Now, in this case from 2021, this case involved the application by a complainant in a trial for rape, in which the complainant was claiming that a right to private life under Article 8 had been breached by the way in which the proceedings had been conducted. The European Court of Human Rights decides in favor of the complainant and points out that the Italian Court of Appeal, which had acquitted the defendants, had relied on biased generalizations that were linking the attire of the complainant, the sexual orientation of the complainant, the artistic endeavors of the complainant, the sexual history of the complainant, to a lack of credibility of the complainant. Okay? Now, this case was brought under Article 8, but if the argument I've presented here is correct, I think it should be possible to bring a successful case of this kind also under Article 6. Thank you.
Many thanks, Federico, for the really interesting presentation, and also for doing so well to stay within the time. Very impressive. I think it'd be great if we just take questions from the floor. Maybe before you ask a question, you could just briefly say who you are, and so that we all get to know who's here at the same time. Tony?
Tony Ward from Northumbria University. I was particularly interested in the RAF issue, which I have written about, and I completely agree with you that there are many cases where this evidence is omitted and it shouldn't be, because any probative value it has is exceeded by its prejudicial effect. But I'm just trying to think how you make this argument work in an adversarial jury system. I mean, in a number of these cases, actually, I mean, there is defence expert evidence, probably a minority. I mean, I know a woman who's given defence evidence in several of these cases. So then it just goes into the sort of black box of the jury. So you say, well, the jury had both alternative explanations in front of them, and they, if they gave weight to this evidence, it must be because they chose to believe the prosecution interpretation. Or if you don't have expert evidence, you say that you can put it in cross-examination, or you could have called expert evidence if you wanted to. So, I mean, how do you get around the argument that either the court did consider the alternative explanation, or if they didn't, it's just because the defence failed to advance it?
Okay, so that's a very good question. In a way, it might seem that my argument works better for jurisdictions with reasoned verdicts, where you can follow the reasoning that the court followed in reaching their decision. But I do think that, for instance, I mean, as we know, in case of jury trials, more often than not, the control, the check of higher courts goes on the instructions that the judge has given to the jury. So it is a way of indirectly checking that fact-finding did not go astray, did not follow some bad routes. So I suspect a possibility would be to assess whether the judge, in commenting of the evidence and the time of giving instructions, has given a fair depiction of what are the possible arguments to be made with respect to violent rap lyrics. But also, I mean, I'm not as knowledgeable as you are about rap lyrics. My colleague from LSE, Abina Obuzubemba, has just written about, has written a couple of things about it, and the latest article is one I've not been able to read yet. But from conversation with her, it seems to me that there are quite a few cases where actually the defense is not allowed to bring in an expert to talk about the topoi and the stylistic rules of the genre, such that the jury, made of lay people, is left to work with the stereotype that if you're a black person, a young black person, you're likely to be violent, or at least you're more likely to be violent than a young white person. If on top of that you also write violent rap lyrics, well, more likely than not, you will have committed a crime of violence. So they're left to work with their own stereotypes. So I think another possible of censure there could be that an expert was not allowed to testify on the matter, and this in a way denies the defense an opportunity to have their stock of knowledge presented in court. But I think you have a very good point.
Thank you. Other questions? Then I have one myself. So I was interested in this this idea of let's take the rape myth example that you provided, and the idea of some sort of Article 6 rights of the victim. But surely, and this quote from Stefan Freisler with fairness is some sort of general guarantee, but it seems to me very difficult to read into Article 6, which refers expressly to the rights of the accused in the determination of a criminal charge, any sort of, substantive rights of the victim. So I can see the Article 8 point, absolutely. That must be taken into consideration, and potentially also in Article 3. It could be really a dignity autonomy issue, but on a fairness issue, I would see that perhaps as asymmetrical in some sense, that the whole point of fairness in the rule of law restricts any sort of participatory rights to the accused, and that this asymmetry might be relevant for our understanding of fairness.
Yeah, so that's a very good point. Now, at the end of the day, it might be more of a nominal matter than not, because as a victim, if you can succeed making a claim based on Article 8, it probably doesn't make much of a difference to you. You get your compensation anyway. And of course, I'm not at all advocating for some sort of a departure from the double jeopardy rule, such that, you know, if a victim brings a complaint under Article 6, the court finds that the trial was unfair, and therefore, if the defendant had been acquitted, a new trial should start. That's definitely not the end point of my argument. I mean, I guess what I'm trying to do is just, you know, follow the steps of the argument, see where it leads me. In a way, I could say, I think in general I'm more of a philosopher than I'm a legal scholar, but sometimes I see myself like that. So I come up with an argument, I try to understand what fairness means, and if it does mean what I, or Stefan, or you say it means, well, I think we should reach the conclusion that the complainant too has a right to a fair trial. And, you know, what are the legal implications of that? I think it's a very fair point that it is problematic to determine what they are, but it is not yet what I'm concerned with at the moment, I guess. And in any case, just to assuage like any sort of worry, like surely I'm not claiming that if the European Court of Human Rights finds that the trial was unfair because of how the complainant was treated, there should be some detrimental consequences for the defendant. That's not my claim.
Yeah.
Can I was going to follow on from that, and I think it was very useful to clarify that yes, you would not expect a vindication of the rights of the victim to simultaneously mean or amount to detriment to the rights of the accused. However, from a more pragmatic point of view, if I may, I have seen this logic in fact. Case law of not just the European Court of Human Rights but domestic courts too, where instead of resorting to a victim's rights ideology to empower the position of the victim, the courts, domestic courts in particular, have done that with the aim of undermining the rights of the defendant. So it was along the lines of, when we speak about the right to fair trial, when we speak about defense rights. There is the asymmetry that I think Sarah has referred to, and therefore we need to do more as a court, as a legal system, to take into account the rights of the victim, and that means that we have to prioritize public interest considerations, and ultimately all this leads to undermining the rights of the defense. So I think from a quite practical, quite pragmatic perspective, there is a concern there. About broadening the concept of fairness to include victims' rights because of the risks that are quite intrinsic to that.
Yeah, I think it's a very fair concern. What I would say in reply to that is that, well, I have to think more about it, but also I think it might be mistaken in some cases to see this as a zero-sum game, such that you give more rights to the victim, therefore you necessarily detract from the defendant. I think there are plenty of situations where you can see that doing something for the victim does not necessarily diminish the rights of the defendant. Take the case of special measures in giving testimony in court. The fact that you use a screen to protect the victim does not necessarily, impinge on the rights of the defendant. Things might get a bit more complicated when you start putting, say, limits to what kind of questions that defense counsel can ask in cross-examination. And there's quite a lot of case law on that in England and Wales. But I think in general it's mistaken to have as a starting point this idea that it's a zero-sum game. When it actually is a zero-sum game, I guess I agree with you that the rights of the defense are paramount because the defendant has more at stake than the victim does normally. And so we should give more protection to the defendant and the victim.
Can I make a short point on that? I mean, just information. In the American Court of Human Rights has been very generous in terms of extending due process rights to the victims. So it's not only at national level the debate, as you said, but in the context of the American Court, that would be a huge debate because they already have guarantees that are clearly thought originally for defendants. Mm-hmm. The court is saying, no, the victim has the right to, for instance, the length of the procedures and things like that. So in that context, the debate could be very interesting.
Thank you.
What is Sabine?
Thank you, and actually thank you very much, especially on the theoretical level. I think this is, it's great. And so my question, again, is going more to the pragmatic view of things. Do you think the court in Strasbourg would be capable of doing what you very rightly asked the court to do, because it would really broaden the idea of, I agree with you that fairness should include that, but could they do it?
I mean, in a way, the case that I presented, JL versus Italy, is a case where the court already does that. It just does it under the heading of Article 8 rather than Article 6.
But that's more a victim issue, and there's also a lot of defense. I would see it more as more as a bias issue. And bias goes many ways, and to understand bias, I think we have to understand a lot of the court system, but how it actually works. That's why I asked.
Okay, right. So we would expect the judges to have a particular sensitivity to the issue of bias that they might not actually have. Considering also the fact that, and I think this is a very interesting point, that biases as stock of knowledge may not be constant across a society, and especially when we're talking about a supranational institution with several societies involved. Now that's a very fair point. Although I think one could say sexist stereotypes and racist stereotypes probably characterize societies across Europe. And so at least when we're talking about these main instances of stereotypes, I think we should want judges that sit at the very top to be aware of their existence, to try and disengage these stereotypes when they try to play a role in their decision making, and also to foster a culture that disagrees with these stereotypes. So I think at least we can start from the main stereotypes and then trickle down and consider the more particularistic ones. But anyway, I think it's a very interesting question.
Can I say that, just on that final observation about the need for the court to be proactive, right, and to shape consensus, if you like. That would be an extremely positive development, particularly in light of criticism of institutions in Europe, and not just in Strasbourg, but also the European Union, as not necessarily showing quick reflexes to, in the area in relation to the work that is needed to achieve anti-racism, to achieve equality, racial equality. And so what you're saying, I think, definitely goes in that direction. But then again, how prepared is the court to intervene in an area where yes, it's an issue that obviously cuts across, but at the same time, it's an issue to which different member states and different contracting parties in the Council of Europe have responded to at various speeds. Some have tackled it because they had to. So in England and Wales, it was a huge issue. It's everywhere. It's in our institutions. We discuss it. And then there are other parts of Europe where we're actually, quite myopic to the fact that there is a racism that is intrinsic in our societies and affects our societies. So from that point of view, I'm not sure there isn't consensus enough around these issues. I'm saying there isn't sufficient engagement across contracting parties in member states so as to trigger a response that is needed. I agree with you, from the European Court of Human Rights.
Just let me follow up. It's not only the court in Strasbourg, but the domestic courts. As the English say, it takes two to tango. Right? So I don't see how Swiss courts would react if Strasbourg told them that they are too sexist on their rape cases. I actually don't know. And as far as I know, the Strasbourg court has done that on domestic violence and some rape cases in countries where clearly they thought that the police did not react to complaints, and that was an Article 2 issue, I think. That they said, you have to protect the lives of female victims in certain cases, and the courts didn't take that. The domestic courts weren't too happy with the scolding coming from Strasbourg either.
But sorry. No, I just want to say that sort of to dispel with the worry is that we're not really working with new concepts. Like, of course, I'm talking about stereotypes and biases, but at the end of the day, we're talking about anti-discrimination, equality, and these are values that are enshrined in the Charter. So I don't really see why there should be any worry with taking these values seriously and pushing them forward.
Okay, we'll take the last question.
It would
from
just
Carol.
be a different way of doing it, but we're not talking about different values. Yeah.
Hi, Carol McCartney from Northumbria too. Brilliant talk. It just made me think of parallel conversations in a slightly different context that I've been having recently with police about. So you'll know in the news recently we had a young black man kept being stopped for wearing unseasonable clothing, like he was wearing a big coat on a sunny day. And so the police were, that's a reasonable search, stop and search, because you can hide knives in big coats, and we know that black men hide knives in their big coats. And of course, so we had a discussion with our police officers about, well, that can't be reasonable, that's just racist, like, admit it. And they were like, but it's not, because our stock of knowledge, as you say, is black men carry knives and they carry knives in big coats. So if we tried to pretend that that wasn't a thing and we're walking around being fair all the time and ignoring our stock of knowledge that we know that knives are in these big coats, then we'd never do any policing. So they were like, you have to let us have these stereotypes in order for us to police, because how would we operate otherwise? So then in the courts, what would the limit be, in as much as how could you say, break everything down from juries about, well, this could be racist, this is part of the patriarchy that have taught us this over years. Like, there would have to be a limit on how far are you going to teach the jury about racism and colonialism and patriarchy and stuff before it becomes irrelevant.
I mean, my talk is not specifically about policing, although I should say that I disagree completely with what the policeman told you on many, many counts. But what I'd say is that I'm not sure I'm even advocating for not mentioning these stereotypes in court at all. My point is more that there should be a counter-narrative, and this counter-narrative should be given space. And the counter-narrative is, no, look, you're completely mistaken. It's not true that black people wear big coats to put massive knives under their coats. That's not what they do. In fact, evidence has shown that such and such and such, that, I don't know, like out of 100 random stop and searches, based on that reason, only in 1% of this, a knife was found. So it should be possible to come up with this counter-narrative. And that, as far as I'm concerned, might well be sufficient for epistemic injustice to be avoided. Assuming that then, when it comes to the summing up, the judge gives a fair depiction of the evidence involved.
You could imagine a trial that would need 3 or 4 counter-narratives though, because it involves sexism and racism.
Oh, sure. Yeah. Why not?
Excellent.
One very quick final observation, if I may, Sarah, and then I might be taking time off myself. But still, I mean, Federico, would you say that your model of exploring, these various narratives in the criminal trial would potentially work better in a continental trial setting? I mean, you have, I think, rightly pointed out Sarah's and John's work on effectively participating in the criminal trial, and you have highlighted the important position that the civil party has in continental jurisdictions. And we are in Spain, so I'm wondering, or in Catalonia, I'm wondering whether your theory works better in that civil party type of
very briefly, possibly yes. And also there's the discussion I had with Tony earlier. Is obviously the case that if you have reasoned judgments, then it's going to be easier for a higher court to assess what kind of reasoning the court followed, rather than having the black box of the jury. But I would say that it is specifically, as precisely in cases where the victim is not allowed to bring civil action, that I think lies the greatest danger. Because the victim that is less empowered than it is in Italy or in Greece, or in Greece, can you? Great. So it's precisely in those cases that there's a worry that the victim is denied a voice. I would say, just to be very short.
Excellent. Well, many thanks indeed,
Federico,
for
Thank you. to leave the table then.
I already see, I think there's quite a lot of issues that we're going to be able to discuss at the end. These
All right.
procedural fairness, injustice.
If Federico goes,
Dismissal
I'll
rights.
come.
Next up we have Dimitrios. You can pronounce your second name for me.
Giannoulopoulos, I will say, given that we're in Spain and people can pronounce that letter better than our English friends can.
Inaugural professor at Goldsmiths in London, and he's obviously an expert in evidence, unlawfully obtained evidence, has written a well-received book, and he's going to speak today on pushing the accelerator to achieve reform, suddenly braking and shifting into reverse. Strasbourg jurisprudence, improperly obtained evidence, and protecting custodial interrogation rights in practice.
And I suppose I have to start with an apology about the driving metaphor. But I arrived in Barcelona. By that time I had already provided my title, and I arrived in Barcelona on Sunday, for this conference, and then I went into the hotel. I spent the night there. And the Barcelona F1 Grand Prix was on, right? Okay, so people were accelerating and braking, and so I said to myself, maybe the driving metaphor, I don't know if it works or not, but at least it's timely, in the context of that. And before I go into that and explain in more detail how that works, the idea is that I want to track movements that key institutions, key players that shape European human rights law, that deploy European human rights law to shape criminal evidence theory and practice. So I want to track various movements, starting and focusing on the European Court of Human Rights. But then arguing that it is really important to look beyond that and also take into account the role and significant influence that the Court of Justice of the European Union can actually exercise these days, particularly through the lens and through the mechanism of the EU directives on common procedural rights. So before I do all that, I want to start with a quick reference to Maximo Langer's contribution earlier this week. So for those of you who were there, I think that was on Tuesday, and so Professor Langer was tracking similarly movements across comparative law. So he started from the United States and moved to Europe, and then ended with Latin America. And he was referring to different ways in which adversarial and inquisitorial law, or Anglo-American and continental European law, if you like, have come closer together. So he was attempting to track convergence between these various systems. And in relation to Europe more specifically, he has referred to the important role, he explained, and I completely agree, that the European Court of Human Rights has played in that regard, and the various ways in which the court's jurisprudence has helped shape convergence, rapprochement between the Anglo-American continental legal tradition, but also more broadly has brought systems in the Council of Europe closer together. At the same time, Maximo Langer explained that the court's jurisprudence was allowing for the accommodation of divergent attitudes that different legal cultures might actually be adopting. And Professor Langer's account, as explained, was part of a broader exposition, so he didn't really have the time to go into the detail. And in a way, that's what I would like to do now. I thought there was a good connection between what he was reflecting on and what I want to argue today. And so I quickly posited there, from the floor, that to this very interesting equation around convergence and divergence that Professor Langer has elaborated upon, we need to very quickly add two key factors. And we need to locate these two factors at two different levels. So the first factor can be located at the purely legal level, and it's what I've already quickly referred to. So we need to examine rapprochement, convergence, the moving of systems together in Europe, also through the lens of the jurisprudence of the Court of Justice of the European Union, particularly when it comes to suspects' rights and the exclusion from properly obtained evidence, with specific reference to the EU directives on common procedural rights. So that is trying to identify convergence and looking at this important development that, as I said, is purely legal. And then we can also, or must also add another factor that can be located at a rather socio-political context, and that is the rise of populist, anti-hero human rights, anti-European, if you like, anti-cosmopolitan narratives across Europe. So, if we are asking the question of how far the European Court of Human Rights and other institutions, legal institutions within the European Union sphere, for instance, can go in bringing legal systems together, then we can't possibly ask that question without also considering the socio-political and cultural context within which these developments are currently taking place. And I'll very quickly offer two illustrations of that. The first is one that is in a way very central to our thinking in England and Wales. So the first political important development is Brexit, and England and Wales now being out of that sphere of legal and socio-political influence that Europe is. And the second, and in that context too, we can locate specific threats directed at the European Court of Human Rights future influence in our jurisdiction. So you may be aware that for a number of years now, the Conservative government has very actively pursued, if not departing from the European Convention on Human Rights, which at one point they were also threatening to do, if you believe that, at the very least to undermine the influence, the impact that the European Convention on Human Rights has in the UK. So again, if we are going to track the European Court's ability to influence the coming together of legal systems and the shaping of common procedural standards, we need to do that from that socio-political perspective. And we could extend the analysis to take into account similar developments, attacks on the rule of law that are currently occurring, not just in the UK, though that is a particularly peculiar and counterintuitive example, I think, for all sorts of reasons, including historical reasons, given the important role that the UK had in the development of the European Convention on Human Rights. But also, you could locate similar trends in Poland, in Hungary, and other parts of Europe. Okay, so all that, you will be interested to know, Sarah, leads to attempts to answer the question that you have asked us to address, namely whether the European Court of Human Rights has contributed to the development of a normative understanding of criminal evidence and proof. So, taking exclusionary rules for the violation of custodial interrogation rights as a contextual case study, I will answer your question in the positive. But I will then link the answer to the wider legal and socio-political backdrop that I have started with, in view of Professor Langer's analysis, to highlight how the court is now backtracking from the normative approach it has previously taken to the exclusion of evidence obtained in violation of custodial interrogation rights, and how we therefore need to look not just within, but also beyond the European Court of Human Rights jurisprudence to understand where European human rights law is heading, and whether it will be able to continue to shape a normative understanding of criminal evidence and proof, or whether it will revert to the case-by-case, fact-specific approach that prioritizes reliability and public interest considerations and moves away from the protection of human rights as the key normative consideration that is determining or should determine the admissibility of improperly obtained evidence. Now, to better conceptualize these constant movements to and away from a normative understanding of criminal evidence, to and away from human rights as the principal consideration mandating the exclusion of evidence obtained in violation of custodial interrogation rights, I have decided, as I explained before, to use a driving metaphor, though I should again explain I take no particular interest in driving, not as a hobby or activity of particular interest at least. So taking a linear chronological approach, I will attempt to quickly describe these movements as follows. So pushing the court, pushing the accelerator in order to achieve a reform, and then braking, and then even shifting into reverse. And if I were to extend that F1 analysis, apparently either F1 cars do not have a shift gear, or if they do, they don't use it because they fear that it's going to completely destroy the system. So putting the shifting into reverse is dangerous, is what I want to metaphorically communicate to you, and I will further elaborate on that with specific reference to the court's recent jurisprudence. So let us start with the court pushing the accelerator first, and that's precisely what the European Court of Human Rights has done with its Saldus jurisprudence. Saldus and its impressive progeny caused tectonic shifts in the area of judicial remedies for violations of custodial interrogation rights, not only in signaling an imminent departure from the historic approach that stressed the importance of weighing up the overall fairness of the proceedings when examining the admissibility of improperly obtained evidence, while also dismissing bright-line automatic exclusionary rules as a viable alternative entrenching the right to fair trial, but also in triggering a wave of revolutionary EU directives, the EU directives that I've already referred to, that are focused on the protection of suspects' rights in practice. So the two were connected. Saldus happened first, and the EU directives followed. So with its unanimous judgment in Saldus, which I have called the European Court of Human Rights Big Miranda moment, so the Miranda rights, Miranda in Arizona from the US, the court introduced an absolute, rights-based, categorical, strict exclusionary rule for confessional evidence obtained during custodial interrogation without access to a lawyer. So the court was saying, if you don't have your lawyer there, there is irretrievable prejudice that you have suffered, therefore an automatic violation of the right to fair trial. So in doing that, it can be argued that the European Court of Human Rights was putting forward a normative understanding of criminal evidence, which I will summarize as follows. According to Saldus, the protection of the human or constitutional rights applying at the police station provided in itself sufficient justification for the exclusion of evidence obtained in violation of these rights, so a normative understanding, regardless of any other considerations that may concern the overall fairness of the proceedings. The court found that violations of the right to legal assistance or the right to silence or violation of other fair trial rights applying to custodial interrogation irretrievably prejudice, as I said, the right to fair trial, and therefore amounted to an automatic violation of that. The link between adopting a normative understanding of excluding confessional evidence obtained in violation of the right to custodial legal assistance and other fair trial rights, and then reforming custodial legal assistance in practice within domestic systems. I think Sabine was earlier referring to, we need to look at the domestic systems, and that's important because there was such a strong link between what the European Court of Human Rights has done, adopting that normative approach, and then influencing movements across a number of contracting parties within the Council of Europe. So with Saldus, the court has driven contracting parties to effect seismic reform, which was long overdue and which in many cases had been very strongly culturally, institutionally, procedurally resisted in contracting parties. And even at the level of the EU legislation. So Saldus happened and EU legislation followed, but EU legislation was being considered for quite a few years prior to Saldus, and then it had stalled because countries like France and the United Kingdom and Ireland had said, no, we don't want to go anywhere near constructing, building common procedural rights in Europe. In previous work, I have explained with a lot of detail how Saldus has led to very specific historic, seismic, as explained, reforms in France, where you didn't have access to a lawyer for the entire 24 hours of interrogation, only 30-minute quick consultation with the lawyer at the beginning. In Belgium, where you wouldn't even see the solicitor, your lawyer, not at the police interrogation, and not even when you were examined by the juge d'instruction, by the investigating judge. And similarly, in Scotland, you would be examined by the police for 6 hours without access to a lawyer. And in the Netherlands, it was a bit more nuanced, but again, they were beginning to pilot, giving you access to a lawyer at the beginning of the interrogation, and only in murder trials. And in Ireland, again, it was quite nuanced. In some cases, you would get access, but it was definitely not a constitutional right. So Saldus breathed new life into all these efforts to create procedural rights, to give the suspect access to a lawyer. And it also, as explained, breathed new life into efforts to create common procedural rights across Europe in terms of EU legislation. But this revolution of suspects' rights was short-lived. In the case of Ibrahim and the UK, the court suddenly stopped putting the brakes on Saldus and leaving it in a perilous state. Confronted with the case, Ibrahim and UK, that raised public interest considerations of the utmost seriousness, so these were the 27 failed attempted terrorist attacks in London that followed the devastating and unfortunately successful 7/7 attacks, and against the backdrop of intense political criticism at the time that Ibrahim was decided in the UK around the need for the UK to potentially move away from the European Court of Human Rights. So in view of all that, in the face of all that, the court concluded that when dealing with violations of the right to custodial legal assistance, so the type of violation that it had previously said in Saldus should automatically lead to a finding of unfairness, of a violation of the right to fair trial. So Ibrahim now said, well, we need to look at the proceedings as a whole. And they said, where compelling reasons to deprive suspects of access to the right to a lawyer are established, a holistic assessment of the entirety of the proceedings must be concluding. And where no compelling reasons have been established, the court must apply a very strict scrutiny to its fairness assessment, but it will still go on and assess the totality of the circumstances and the overall fairness of the proceedings. The Grand Chamber then drafted a non-exhaustive list of factors that I quote should, where appropriate, be taken into account when examining the proceedings as a whole, including whether it's a very long list, so but it's all about the reliability. So the court said we need to look at whether the applicant was vulnerable, the quality of the evidence, the nature of the violation, and also I think something that Federico mentioned earlier on, whether the defendant was given an opportunity to challenge the admission of the evidence. So as John Jackson rightly points out, in setting out these factors, that courts would have to consider when establishing whether the admission of the evidence obtained in violation of custodial interrogation rights had rendered the proceedings unfair as a whole, the court was, I quote, putting a high premium on the weight or reliability of the evidence against the defendant, and also on the quality and significance of the evidence in the context of the evidence as a whole. And in jurisprudence that followed on from that, in a quite linear way, and shortly after Ibrahim, including with Boys and Belgium, Simeonovi and Bulgaria, and Doyle and Ireland, the court has gone on, I would say, to crush Saldus's letter and spirit, throwing Saldus off the rails and shifting into reverse, back towards the overall fairness of the proceedings test, and away from bright line rules and a normative understanding of excluding improperly obtained evidence to protect the right to fair trial. In the light of all this, John Jackson's conclusion that Ibrahim and its progeny, coupled with the court's recent jurisprudence on the sole or decisive test in relation to hearsay evidence, signify that the court has drawn back from its more activist stance of setting fair trial standards. That observation that John Jackson made is quite inescapable. And I would add that following its brief Saldus moment, the court has abandoned the effort to normatively prescribe evidentiary remedies for violations of procedural rights intrinsic in the right to fair trial, and that it has opted for a discretionary approach that prioritizes the reliability of the evidence and public interest considerations over normative considerations relating to the need to give effect in practice to fair trial guarantees. A number of important questions follow on from that, and I can assure you that these questions are very central to my concluding observations. So, first of all, we need to ask what are the power dynamics, because from the outset I said, we need to locate all this at the socio-political context, not just legal, this is cultural, this is socio-political. So what are the power dynamics that caused the European Court of Human Rights to adopt a quite pragmatic, multi-factor discretionary approach that prioritizes the reliability and public interest considerations over the protection of human rights? Notably the right to fair trial, one of the cornerstones of its modern jurisprudence. I would say that adopting such an approach is quite counterintuitive. It's the European Court of Human Rights, right? It's not the European Court of the quality of evidence or the reliability of evidence. So it's quite counterintuitive, I repeat, for the European Court of Human Rights to adopt a position that, instead of advancing human rights in the way that it was, is actually backtracking from that position. And I would quote one of the only two dissenters in Ibrahim, Julia Lefranc, the Estonian judge at the European Court of Human Rights, from an occasion, actually in Athens, we were in the same panel, and she spoke extrajudicially on Ibrahim, and she said, we should not forget that our mission, the mission of the European Court of Human Rights, is to protect the fragile rule of law. We must stick to protecting human rights in order to remain true to ourselves. The European Court of Human Rights must set the example and confirm our common attachment to human rights values. The European Court of Human Rights has to look itself in the mirror, wrote one of my students in Athens. I teach a postgraduate program there, when providing reflection as part of an assessment that I centered on this case. So again, it made me think it's about the point of all this being counterintuitive. It was Julia Lefranc that was speaking to this point, and my students reacting to Ibrahim. They were all thinking it really doesn't make sense. And then I would add, it follows on from that, not only this is counterintuitive, it's also counterproductive, because the court's Miranda moment had started the revolution of suspects' rights, reminiscent of the revolution of constitutional and criminal procedure that the Warren Court had effected in the United States, for instance. But then Ibrahim and its progeny signaled that either the court did not know that it had done so, that it had started this transformation on the ground of criminal procedure rights, or maybe it knew, but it didn't care. And other considerations, reliability, public interest considerations, had actually taken priority. The court's agnosticism of this, the applications of its own jurisprudence, I think, is quite striking. We can also put it differently and say that there is a really troubling oxymoron at the heart of Ibrahim and its progeny, and that is that it goes against existing efforts in contracting parties to guarantee the right to custodial legal assistance. So the court started this revolution. Domestic courts have responded. The executive in member states and contracting parties have responded. They quickly introduced, in some cases quickly, in some cases a bit less quickly, more slowly, introduced legislation. And yet, in the face of Ibrahim, how are they now to respond to this counter revolution? Are they supposed to go back and review this legislation, move away, undermine its effect? This is the question about Spain, for instance. So, observers in the panel on Tuesday were responding to comments on Twitter and saying that, well, in Spain, the EU directives that were triggered by the European Court of Human Rights jurisprudence have played a very important role, and we have seen changes in the law in action. So let me conclude. I'm sure some of these issues we can explore in more detail in Q&A. But just to conclude, it's very important to take into account that as we speak, there are currently a number of developments that are happening at a number of different levels that the European Court of Human Rights has shaped criminal practice in relation to the admissibility of improperly obtained evidence because it adopted the normative consideration, and now it has backtracked. So the focus is now, I think, very much on the Court of Justice of the European Union. It will be very important to see how it is going to react to these developments at the European Court of Human Rights, and whether it will interpret, and I conclude, the EU directives with a Saldus kind of approach, or is it going to adopt an interpretation that is going to be much more favorable and much more in line with Ibrahim? Thank you.
Thank you very much, Dimitrios. Questions? Federico is jumping in.
Thanks so much, Dimitrios. So if I understand correctly, that the idea is that there's being sort of a shift from
we might, I put it in this terms, you might disagree, but with like from enforcing like moral values, rights, to enforcing epistemic values. So a shift from having hardline rules that say you breach this right, therefore the evidence is going to be excluded, to instead having a sort of an open-ended assessment where the notion of reliability plays a crucial role. So I mean, we see this, for instance, in the case of confrontation, which you mentioned. So where there's the hardline rule, and then after a conversation with the UK courts, the European Court of Human Rights comes to the conclusion that roughly, like if the evidence is reliable, okay, we can actually let it in. And maybe also, I'm thinking about the case of Gafgen, where it seems that the epistemic values trump the moral values, when the court says we have to look at what role the evidence actually played, and if the evidence that some argue should have been excluded was not determinative of the conviction, then why do we care so much about it? So it seems the epistemic aspect of the decision is now more important than it used to be. Now, I know that in saying this I might actually be undermining my own talk, but we said...
I'm intrigued that my paper is doing that.
No, that's referring to what I'm about to say, but it came up in conversation with Sabine. So of course, we need to care about the national institutions. We need to have a supranational institution that pushes them to do what they actually can do, as opposed to putting standards that are unachievable. So the question here is it the case that reliability it's easier to build a consensus on reliability than it is to build a consensus on the moral values, and therefore the court is taking, whether consciously or unconsciously, that avenue?
Can I respond by using what you said earlier on to respond to my question? So you said it's not a zero-sum game, and I will deploy that here if you will allow me to do so. I mean, reliability has always been important, and then one looks into improperly obtained evidence or the exercise of suspects' rights. It's the absolute starting point. It's evidently you are spot on there, where consensus will have easily formed, right? And this is why, in a way, the court, with Seldoos and its progeny, was able to finally take that next step. It was quite a dramatic step, and move from the overall fairness test to finally saying, well, we need to take these rights seriously, to speak like Dworkin. We need to do something about them. The fact that fundamental components of the right to fair trial are violated cannot be without consequence. And we may disagree about how far we go in attaching consequences, what specific ramifications we attach to these violations, but surely we agree that we need to take these violations quite seriously. And I think this is what the European Court of Human Rights was doing there. So yes, reliability, the starting point there, and you kindly said you read my book on improperly obtained evidence, and what I was trying to highlight there is that confessional evidence and suspects' rights was the obvious sphere where some consensus could be formed and some convergence could be observed around automatic exclusionary rules, for the very important reason that it starts with reliability. So let's not forget here, we say these are procedural rights, so these are just normative, but they are also very much about the quality of the evidence, right? So the exercise of these rights is supposed to ensure that evidence is not obtained in a way that can render it unreliable. So reliability considerations will be central to that. I'm concerned, as you can tell, about the direction that the European Court of Human Rights has taken in this area.
Other questions, thoughts?
Taking Carol's example from before and your call for a more active stand of the European Court of Human Rights. Now, if they would find the bloody knife in the big coat someone was wearing, would you think there should be an exclusionary rule if in the end we find out totally biased the search because it was at one time they found a bloody knife. They stopped 100 people, black, with a big coat, and only once they found the bloody knife.
Yeah, I mean, in a way, the extremity of the scenario reminds me of the ticking bomb scenario. You know, you put it so well that you want me to say that yes, we should admit the bloody knife. No, you are logically forcing me to say that. Your argument does, you know.
I didn't feel any coercion here.
No. Intellectually speaking, you know, intellectual coercion. No, there is logic in that. You know, it's what you're saying, Sabine, is quite intuitive. You know, it makes sense. Like if you were to ask 100 people whether they should, we should use the evidence in that scenario, I'm sure, you know, the vast majority of them would say absolutely. And in fact, that's so. This is where I find it most difficult to advance my thesis for strict exclusionary rules. On the other hand, you know, you have to ask yourself. I go back to your scenario because you said that the police, or maybe Carl's scenario, that have stopped and searched 100 people without reasonable suspicion. So at the end of the day, you know, we have to ask ourselves the question: as a society, do we want to be in a position where we allow our police, or our police feel that they have the right to stop and search 100 people, you know, in southeast London, where the vast majority will be from particular communities, let's say, and subject them to these deeply unpleasant, hugely troubling situations, in order to ultimately, you know, come across a situation where we will have found the stolen, you know, the property that will be demonstrating quite clearly the guilt of the accused. I say, and I totally understand it's a difficult position to take, that we shouldn't. I don't want to live in a society where, you know, the police can do that in the streets where I teach and to the students that I teach in southeast London. I wouldn't want to be in that position. And similarly, you know, if I were in the US, I wouldn't want the SWAT teams or police to, you know, knock on my door and 2 seconds later just bring the door down, come in, and, you know, effect police searches that would go beyond what the Fourth Amendment there, for instance, allows. But I do recognize the strength intellectually of your argument.
Thank you very much. Further questions? Yes?
I have a question regarding the margin of appreciation. As Professor Lander said, it's important for you to accommodate the many different legal systems. So the human rights do not impose in a way that evidence should be produced specifically, but we leave a certain margin of appreciation. But at the same time, as you said, this openness of the margin could be used for, I would say, political reasons. And don't you think that maybe this use is related to the fact that we don't have actually a definition how broad should be this margin of appreciation in order to then to the states or the contracting parties do not undermine human rights?
Well, I think that's an excellent question. The margin of appreciation is a very important mechanism, and to link you know, your observations on the margin of appreciation to the socio-political and cultural context that I was earlier on explaining, we always need to take into account when providing analysis of developments, you know, within criminal procedure or criminal evidence. I think it is a mechanism that takes some pressure away from the European Court of Human Rights, and in a way that, you know, it allows it when it feels not very confident about its ability to forge consensus across the Council of Europe. It basically allows it to, you know, take a step back and move away from a more activist approach. However, surely, you know, there comes a point when the European Court of Human Rights has to choose between rights in the Convention as, you know, theoretical concepts and doing something about them to ensure that they can be effective in practice. And I'm sorry, but I think it's deeply worrying that in France, for instance, they have been discussing giving the suspect access to a lawyer for over 20 years. You know, I was there studying for an LLM master's degree in 1999, And we were discussing the reforms that the conservative and government of the left government had attempted in 1993, and then nothing happened, and finally they gave the suspect access to a lawyer for half an hour, and then 2 years later they gave them they introduced the duty for the police to notify the suspect of the right to silence. They didn't even have that. They did not even have that, and so they introduced that in 2002. And again, a few months later, they took it away. So, quite honestly, had it not been for Seldues, we would probably still be in a position in France where you would have the police questioning suspects for over 24 hours. What about the reliability, right? When you have that, when you have someone confronted with the inherent coercion of the police station, to speak like the court spoke in Miranda in the US, without any access to legal assistance. And what about effective participation or active participation in the criminal trial? You know, your concept and John's concept about empowering the suspect. I think, you know, the Seldues jurisprudence had a magnificent effect on the ground. It has pushed finally all these countries to do something pragmatically about the right to legal assistance, and so again, it is deeply concerning that the court has now moved away from that. I mean, don't get me wrong, there will be difficult cases. In fact, I think that, you know, Doyle, for instance, was a very difficult case. The same with Simeonovi, and so the court was confronted with cases where, you know, the defendants before it were quite clearly, you know, culpable of what they had been charged with. But you know, how do we tackle this dilemma between making real the promise of human rights on the one hand and then ensuring that public considerations are given sufficient attention?
Excellent. Well, Dimitrios, many thanks for your presentation.
Thank you.
And now, as I'm on next, Sabine is going to chair my session, so in case I don't have to ask myself questions afterwards, it'll be a bit awkward, I think.
Okay, so I'm in
Sabine, do you want to come?
I think I can do it from here. So I'm in the very lucky position to introduce Sarah Summers, who we all know. She's teaching criminal law and teaching actually fair values to the Swiss students and courts. And she came to that position because many years ago she was in a PhD to Glasgow, but somehow she got stuck in Zurich. And since then, to the benefit of Switzerland, she didn't leave. The floor is yours.
Thank you very much. I am going to speak today on the epistemic ambitions of the criminal trial. And so the question is, well, what are then the epistemic ambitions of the criminal trial? And it seems clear at the outset when we're going to think about this sort of issue, that the answer is going to be influenced not just by the characterization of the aims of evidence or proof, but also the characterizations of the ambitions of adjudication more broadly, and then also about expectations about the relationship between the aims of proof and those of adjudication. So I wanted to just begin by very briefly outlining what I'm going to call like or what we all call sort of the instrumental account of trials with side constraints. It's usual for the goal of the trial process to be characterized in instrumental terms as focused on truth. The aim is to establish whether a disputed claim is true or not, on what might be described as this received view. This instrumental conception of trials somehow mirrors conceptualization of the epistemological considerations in a veritist or Lockean understanding of truth as involving just something like a high degree of confidence in issues of accuracy or inaccuracy of the facts. So according to sort of the rationalist tradition that Federico has already mentioned, today the main goal of legal adjudication is somehow, and of proof, that rectitude of the decision, the pursuit of truth is seen as a means of justice under the law, according to Twining, to be pursued by rational means. And this suggests, of course, then that the procedures which should be followed should be designed principally to maximize the chance of accurate outcomes. So that's how it kind of fits together. And to the extent there's acknowledgement that the adjudication proceeding should follow other values, values such as fairness or whatever, these values are then seen as secondary to this principal aim of accuracy or rectitude or whatever you want to call it. And rules which then limit the use of evidence in pursuit of values like fairness are seen as side constraints, as extrinsic to the process of proof, that potentially interfere with the proper epistemic ambitions of the trial in some sense. So the idea is then that in some circumstances procedural rules might require the prohibition of evidence, even if this is at the expense of accuracy. So the symmetry then between epistemic and procedural values is disturbed, maybe necessarily according to some, although some would reject all goals altogether, in pursuit of these other goals. So we've got like an idea of evidence supporting rationality, and then we've got kind of exclusionary procedural rules for fairness, which are seen as departures somehow from this sort of concept. And I want to highlight just 4 aspects, I think, of this account which are maybe relevant for us. So first, there's clear recognition that the epistemic ambitions of the trial, be that a civil or a criminal trial, I'm speaking quite broadly here, are somehow closely tied to the aims of adjudication. So the aims of the epistemic ambitions of the trial are connected to the aims of adjudication. That's an important point, I think. Second point, I think, these epistemic values that we have are seen as common to all types of legal proceedings. I think that's very much something that's been discussed in sort of the common law evidence tradition or scholarship. The idea that we have an understanding of evidence which can be somehow separated from the distinctive natures of types of adjudication. Then third, legal adjudication is understood as being capable of being divided, clearly divided in some sense, into accuracy of outcome, or accurate outcomes on the one hand, and a fair process on the other. And fourth, truth on this account is really understood in a veritas sense as involving a high degree of confidence in the accuracy or inaccuracy of the probative facts. And the relationship then between legal proof and more fundamental epistemological concepts that we find in the philosophical literature, these are generally underdeveloped, I would say, in the legal literature. Of course, there's a lot of exceptions of people that are writing on this. Pardo's written important stuff. But still, it still seems a bit blurry. The question is then, can the degree of confidence in the accuracy of the facts then be guaranteed by mere belief, or do we need something more? Do we need some type of justification? Is that justified true belief, or is that knowledge, or something even more than that, understanding? Who knows? All these questions remain a little blurry. So that's just like the kind of the position that I'm departing from, and it's my position then that this conceptualization of evidence law has come under pressure, particularly in the criminal context, from the rights-based regulation of evidence which has been developed by the court in Strasbourg. And so I'm going to argue that this approach being developed by the Strasbourg court calls into question at some level this instrumental understanding of criminal trials. That's important. And as a result of that, calls into question also the possibility of cleanly distinguishing between accuracy of outcome and process, and as a result of that has implications for our understanding of the epistemic values of the trial. So that's kind of the sort of argument that I want to make here. So first then on the aims of criminal adjudication, obviously the normative regulation being developed by the court is closely connected to the institutional framework, and in particular to the importance of the rule of law. I think with Fuller we might see the defining characteristic of adjudication, of legal adjudication, as grounded in the particular form of participation that it affords to the party. So to be meaningful, there will be a number of consequences. The party obviously has to have a chance to present arguments, to present proof, this sort of thing. And we see that very much in Article 6.1, this conception of participatory involvement in adjudication, with this idea that the parties have to have the opportunity to present their case under certain procedural circumstances. And I think what's important here is to really notice that the extent of this participation on the Article 6 account differs in civil and criminal cases. That's important. And we have to think first about how it differs and then why it differs. So how does it differ? We all know there's a whole bunch of reasons why the procedural regulation in Article 6 differs. It differs on the issue of the presumption of innocence. So obviously there's the 6.2 point. I think there's a lot of dispute about what the presumption of innocence means, of course, but I think we can agree that it involves the burden of proof being on the state. It implies in some sense a state monopoly on punishment. That's important, the role of the state in criminal proceedings. Then we have, very important too, distinguishes in the context of Article 6.1. In criminal proceedings we have also the right to remain silent, the privilege against self-incrimination. It's a very distinct understanding of the right to be heard, which differs from civil proceedings then. Again, because of the role of the state. Then we have the rights in Article 6.3, the minimum rights of the defence. It's true that Strasbourg has said these rights may also apply in civil cases, but nevertheless there's no question that these rights in Article 3 have a different quality than they do in civil cases. And we see that the court has said very expressly, it's referred in a number of cases to the fact that the contracting states have greater latitude when dealing with civil cases concerning civil rights and obligations than when dealing with criminal cases. So I think it's important for us to think about what does that mean and why is it the case? So I think there's something clearly distinctive, and that's very important. I think that's something that's under-recognised in the procedural literature on trials. There's something very distinctive about adjudication in criminal cases. So this existence of a specific or a distinct normative framework suggests that there are in fact normative issues which are being discussed here, which are different from those in other types of proceedings. So it's important to us, what is it that makes criminal proceedings special? What is it about that means that we need this other type of framework? And I think there's two things that are worth stressing. One, of course, the state monopoly on punishment. So the particularities of the role of the state in this context. The state is equipped with dramatic powers, coercive powers in the context of the pre-trial, of the police at the prosecution stages and so on. Broad coercive powers which allow for dramatic interferences with the rights of individuals. That's clearly very important. But it's not enough, of course, because we have other types of state sanctions as well. So criminal trials are certainly distinctive in that they allow for attribution and also attribution of liability, imposition of punishment. And then we also have to think, well, what is it that's distinctive about punishment as opposed to other state-type sanctions? And we can't get round, I think, some sort of discussion about notions of wrongdoing, not necessarily moral wrongdoing, not necessarily the type of things that Anthony Duff has been discussing, but we can't get around the fact that the distinctive aspect of criminal proceedings or criminal cases is that it does allow for some notions of blame, attribution of culpability, some sort of blaming account which makes it particularly distinctive and which calls it then for particular normative framework. And I think that's very important to keep in mind because this connection to punishment, the importance of justified punishment as part of criminal adjudication, the relevance of lawfulness of Article 7 is something that one has to think about carefully when thinking about the scope of Article 6. So it feels like that feels all a bit abstract. I want to mention also the same case that you mentioned earlier, actually, Berani against Albania, as kind of like something which maybe exemplifies this relationship between fairness and lawfulness. So this is like a case on manifest unreasonableness, and the victim was shot dead in a bar by two people wearing motorcycles helmets. And he was later arrested as the applicant, the accused, was arrested later as fitting the description of one of the suspects, although bearing in mind they'd been wearing helmets. But he had long hair. So he had long hair, there was some sort of proximity to the crime scene, although it was a few miles away, it wasn't particularly close. There was some sort of proximity to a motorbike that may or may not have been used in the shooting. The other suspect couldn't be traced. There was in the trial several witness statements. The witnesses had been questioned in the pre-trial without the defence being involved at all. They hadn't been heard at court or at court appeal. And the important is, well, these witness statements weren't submitted either by the accused or by the state to the Court of Human Rights. So the Court of Human Rights couldn't really make any evaluation of the importance of the witness statements in this case. That feels important. Another important fact in this case, which is just mentioned very briefly, was the fact that the victim, a few years earlier, had actually murdered the applicant's brother. So the suspect, there was obviously some sort of issue of motive or connection to the case. So in Strasbourg said, well, we're only going to intervene if this is completely arbitrary or manifestly unreasonable or so on. And then they looked really at what the evidence was. They said, we've got it's based in part on these witness statements. None of the witnesses appeared in court. They were clearly relevant to the case, but we can't really establish like how relevant they were. And then the court said, well, we can't find any other convincing evidence. No indication that the applicant's fingerprints were found on the motorcycle. It could be adduced that he'd kind of fired the bullets from this weapon. In fact, they hadn't even found the weapon. So they didn't really have any other evidence. And then they said, Strasbourg said then in this case, this is a manifestly arbitrary judgment. So here we see a real play-off between fairness and lawfulness. On the one hand, you have these questions about, we just no real evidence that this person was culpable, and at least not in a 7-1 sense of culpability. At the same time, we have this connection to the witness evidence, to the opportunities to question witnesses that weren't there. And the question is how sensible it is to try and separate out these things and trying to insist that we look at this in terms of procedural fairness or some sort of justified punishment or justified culpability in the rule of law. And so I just want to be a little sceptical about the possibility in a lot of these cases about clearly distinguishing between substance and procedure, between outcome and accuracy of outcome and the process of which we're making decisions about outcome. How am I doing something for the time?
Well,
5 minutes. Carrying on. Good. So then what's the conclusions from this? Well, I want to say that I think criminal adjudication must be seen as following intrinsic aims, not purely instrumental aims. In the sense that the procedural propriety has an intrinsic non-instrumental value, which is connected, of course, to notions of citizens' dignity. I mean, TRS and all this type of thing. We all know that, but also I think, and that's important to some sort of to the institutional context, to the idea of the whole nature of criminal proceedings as maximizing, as allowing for the maximization of freedom under certain circumstances and protecting the rights of everyone, especially the guilty, in the context of these proceedings. So I'm very sceptical here about distinguishing clearly between accuracy of outcome and process. I think these are not matters which can or should be separated. I think that's flawed. Values like legality, like fairness, they shouldn't be seen as normative side constraints on criminal adjudication. They are the essence of adjudication in the rule of law, would be my position. And the question is then, what are the implications now about that for the epistemic ambitions of the trial? So if we accept that our theory of adjudication or theory of evidence depends on our theory of adjudication, then we might also say that there's space here for a distinctive theory of criminal evidence, about a distinctive account of the epistemic values in criminal trials as opposed to civil trials. What I'm definitely not arguing against is some idea of, I'm not arguing against proof or truth. There's no getting around the central importance of truth as the aim of the criminal verdict. I think it would be absolutely absurd to argue otherwise. I mean, we care very, very much about truth or falsity of the verdict, but the truth in the context of criminal adjudication, I would say, is not just an instrumental account, or shouldn't only be understood in instrumental terms. It has also some type of intrinsic value. And the fact that this all leads me to the fact that I think the epistemic ambitions do depend on the practical context, on the practical issues at stake, Stanley and so on. In the context of criminal proceedings, the epistemic values or the extent of the justification is likely to be higher. And I don't think I have too much time to make my case for knowledge. So I'm just going to say that I think that we need more than just belief or true belief or the Yordi's acceptance plus account, and I would be rather going towards a knowledge account. But yeah, maybe.
Thank you very much, and I think, her observance that's the Swiss way of, and now she constantly looks, perhaps we come back to knowledge. So Federico.
Thanks so much, it was really interesting. So I don't know how helpful this is going to be, but I wonder whether the notion of standing punish.
Mm-hmm.
And by this I mean like a moral authority to punish can
Yeah.
be helpful in creating your theory of education. And this being a notion which, as usually, Anthony Duff's written, Matt Travers, if I may, my wife and I have written a little bit on it in the volume Philosophical Foundations of Evidence also.
I'll
But,
check it out for sure.
But although we do it more from a critical perspective than from
Yeah.
a sort of an endorsement perspective. But so I guess someone could argue for the state to punish legitimately, the state must have moral standing to punish, and then try to elaborate what are the different requirements that the state must satisfy for moral standing. And we can include like epistemic credentials and moral credentials in terms of respect for procedural values. And you don't necessarily need to establish a hierarchy between this. You can just say that they all go in the mix and contribute to the standing of the state. I'm not sure this is going to be a successful way of seeing, I'm looking at the matter, but it could work.
If I understand the type of thing that you'd say, like, I don't know, moral values like integrity and this type of thing.
Yeah, that's, yeah.
And that you'd characterize sort of like, yeah, I would be, I feel like, I mean, that's interesting. I mean, Anthony has worked a lot on this, hasn't he? And I've actually read your paper on integrity where you argue against him. I know the arguments, but I think you get into the situation that it's certainly not my argument, it won't be my argument, I don't think, that lawfulness, like lawfulness per se, or unlawfulness of certain types of evidence, the use of that would then somehow interfere with the moral standing of the state to prosecute certain types of crime. And then the question you get down to is then, well, where are you going to draw the line? And you've got people like, I don't know, Ashworth and things that had broader accounts and would have included a lot, and people that don't want to. I mean, if we think back though, in the early case, it's quite interesting, the early case law on 6.2, because 6.2 refers to presumption of innocence in accordance with the law, there was a big discussion actually in prior to Schenck against Switzerland about whether that meant, in fact, that all evidence that was admitted had to be lawful, or at least in accordance with domestic law, and potentially non-arbitrary and so on as well, but non-lawful, and that was then argued but rejected by the court. So I don't know. I don't know if moral. I like the argument in some sense, but I don't feel like that's that's going to do me much use. In some sense, of course, it's to do. But on the other hand, I do think that of essential importance is the role of the state. So that's obviously something that's like under the public law conception of criminal law.
I should say, I think I agree with you. I don't think it's going to be on much use, but I still put it out there.
Okay, thank you.
Karen?
Thanks, it was interesting, but I noticed, because this is a thing I've always been obsessed with about whether the accuracy of the evidence could be so accurate, so reliable that we would just say it doesn't really matter then about the other things because we know we've got the right guy. And you yourself mentioned there wasn't even a fingerprint on the motorcycle, like as if that would make a material difference with it to the rules of adjudication, because there's something about the fact that, well, the evidence seems so, we know that eyewitnesses are unreliable and this seems really unreliable kind of evidence. But if we'd had a fingerprint, that would have been different, are you saying? Like,
so I'm just that was just actually what the court was saying. Like, no, that was just kind of that was their sort of reasoning, not something that I'm endorsing as such.
okay.
But
So,
but it's true. I mean, in that sense.
yeah. So then, is there going to be a situation where, and I mean, this is something we're looking at in terms of like AI and facial recognition and stuff. Is there going to be a point where the accuracy of the evidence is such that we know the person did it, so we don't need to worry about all the other aims and fairness and things because we know we got the right guy. It doesn't really matter that it was.
Well, I mean, I suppose my response to that would be like, how are we making these judgments about accuracy in the absence of certain types of procedures in the rule of law? And that's that we have certain processes, and these types of processes allow us to make decisions about accuracy. So that's one part of the response to that. That I'm a bit sceptical about the possibility of divorcing. There's cases, of course, there's other ways of thinking about resolving issues of disputes. It doesn't need to be a legal form of adjudication. But if we are going to say, no, we're going to actually look at these disputes and we're going to resolve these disputes by way of adjudication, the defining aspect of adjudication is the process. So it doesn't seem to make much sense then to say, well, we're going to solve these disputes by way of adjudication, and then in fact well, does it matter if we're actually following the procedures? It doesn't. I mean, that doesn't. Then okay, but then it's just not adjudication in a true sense. In that sense. So that would be part of the issue. And the other part would be I'm sceptical, as I tried to explain. I'm sceptical about understanding of an instrumental understanding of truth, just in terms of only in terms of high confidence or in probability of an accurate or inaccurate.
That's really good, because it's like about 20 years ago or something, I wrote this stupid little thing about in 2020 or some futuristic thing I felt like it was then, we'll just have DNA courts where we don't need a trial because it was your DNA, so we just have fast track things. And like I sort of posited as, well, this would be outrageous, but it was in this like magistrate's journal or whatever, and loads of people wrote in going, yeah, that's a really good idea. And I was like, no, I was trying to say it was a bad idea. People thought it sounded good.
But you know, you could take that further, and now one of my master students said actually now cars could hand you the speeding tickets. Because the car knows that you speed. There's no discussion about that. So you speed, your car just, you know, withdraws the money from your bank. Would that be fair? I mean, you could raise a defense like there was my sick neighbor and I had to bring her to the hospital. That's what I had. So you could still raise that, but other than that, and that's, you know, the sort of accuracy.
Yeah.
But following up your discussion, wasn't that the Gefgen case then? You know, where in the Gefgen case, I don't know whether you remember that in Germany, actually a law student who got hold of the son of a very rich banker, and then, you know, the boy died very early in the process, but the police didn't know and they threatened him with torture, and he disclosed the whereabouts. So in the end, we knew it was him, but people were not willing to use that as a result. So they played around in German procedure to make him confess. They could not use what they had on the poison. Also, we don't have that rule in Germany, but they could not use it because they struggled so much with what you two discussed. They had, in that tragic case, they had the culprit. But they could not accept that you get that by threatening someone with torture.
Because it opens Pandora's box, you know, what happens next if you authorize that, you know, how far
and especially,
can police go next time that they face the
especially
same.
because the person, you know, this police, he was very high ranking, he was second, and he bragged about it in TV. That he said, you know, that's how we will handle these cases. And he got promoted. So Germany, the Strasbourg Court failed Germany on, you know, promoting such a person. So I think that's that's a bit your case. But I would like to follow up. We have a few minutes, don't we?
Yeah.
On your, you know, you made this important distinction between criminal law cases and civil law cases, Article 6. And we had this discussion about the victim before. Doesn't the, you know, the role the victim plays today somehow blur that? Because when the European Convention on Human Rights was drafted, it was actually, I think, about protecting the individual against the state power, especially in criminal trials. And the victim was not, at least not in continental European systems. The victim was not in the picture then. But now we have the victim, and somehow the distinction doesn't make that much sense anymore. I don't know. I didn't in your thing.
Yeah, I mean, well, obviously I'm a bit sceptical about giving affording the victim any sort of participatory rights in the sense of Article 6 in the criminal proceedings. Of course, their interests have to be protected, and particularly the Article 8 and Article 3 interests have to be protected. But the idea that they would have strong participatory rights in any true sense, in the sense of in the criminal sense, I find it difficult to understand.
Well, that would also feel probably well. And then, you know, because she couldn't speak about knowledge, I know she would have liked to. On Sarah's behalf, I put your brains. So we were discussing whether belief and knowledge, which one is the more important for a criminal conviction. I said knowledge. She said belief.
No.
Ah,
No, like belief. I mean, the belief is definitely. I think that I think we'd all agree that belief is not enough in itself. I think as soon as you have any notions of arbitrariness or something, then belief is not going to be enough in itself, because
okay,
just the fact that I believe that as the judge is so you're going to need belief plus something, and then the question is like what is that something, I suppose. Like what is our justificatory position on that? And that's there perhaps we have a different opinion. But I think I'm for knowledge, Sabine. I don't know what you are for.
That takes us right back to Federico with that belief can be based on my racist views. So it shouldn't be according.
I would ask, what does a jury believe or knowledge? And the difference between continental and I think it's...
And
like in French, you would say intime conviction. You really have to be convinced.
yeah, so I suppose Jordi's also written an important paper, right, on belief and whether it's not better to conceptualize this in terms of acceptance rather than belief. I mean, that's a big thing. And then I feel like the issue though is then just the extent of the justification of this. You know, is the belief in itself enough? And I think I don't think anyone would subscribe to that. From what I've read in the literature, I don't think anyone would say that belief alone is enough for legal proof. There has to be something. There has to be some type of justification. But there is a complete lack of consensus then on what constitutes sufficient justification. Whether that's justified true belief, whether that's knowledge.
Yeah, but then the jury does not have to justify their.
I mean,
Judges justify whatever they want. It's not a fair depiction, but they are so different.
But they should.
The jury, I mean, the jury do have to. I mean, there's a whole bunch of cases, right, in Strasbourg on jury trials, and also, I mean, very important in the British system, then the direction to the jury as a way of explaining things. I don't think it's the case.
And yet the jury can go on and decide an outcome that might be completely out of line, out of touch with what knowledge of the particular facts might actually dictate. I mean, we've similarly had that case in Bristol on the topic of the statute, and I think it required very constructive, very creative kind of interpretation for the jury to accept the defenses that it did, and there was a lot of criticism. The outcome that it reached in the end could not be supported by the knowledge of what had actually happened in that case. I think that opens up a different kind of discussion, but isn't that an instance where the jury can actually operate with belief as the driving force, as belief in the fact that finding the defendant guilty, for instance, would be an unfair outcome, and therefore still going for that.
Probably our last question. Since in jury trials, we have different functions of the judge, giving the directions and looking after what you call, not the fairness and all that has to be in the instruction or in the exclusion of evidence before. But the fact finder in an adversarial proceeding, if it's a jury trial, it's a jury alone, and all they decide on is whether they, believe in the accuracy of the evidence, right?
Right, but I mean, but there's still a direction to the jury. The jury is there's plenty of people here that know better than me the jury directions. But I think one has to be a little bit careful sometimes about looking about what's happening in practice. I mean, in Zurich, when we think about the judgment, then there's a judgment in court, and that's often written then by the court writer later. And the judgments are maybe 300 pages long and very, very well reasoned. Whether these reasons are the reasons that the judge was swayed by in making the decision is another question. So
that's a Swiss system. The judge, in theory, must not be a lawyer. The judge is the fact finder, and then you have the clerk writing reasoning, for the belief the judge has found.
Sometimes before the verdict.
Yeah, and sometimes actually these clerks, because they understand that is not the correct outcome, they will write a reasoning that is very easily squashed by the federal court. Because they make it clear we don't believe them. Okay.
Ahora la sanción, hay un desayuno que dura media horita.
Okay. Okay. So we thank